Hey everyone, and welcome back to Uncivil Law. For today's episode, we're going to do a deep dive into an older Supreme Court case. We're going to do an oral argument reaction to the case of Hustler Magazine versus Falwell. This was a big case at the time, 1987, and it deals with the First Amendment. And to start with the thing, we of course have to start with the complaints, really. We have to start with the thing that was being complained about. So this is the ad that ran in Hustler Magazine in the 1980s, and I will read it to you. The ad is entitled, Jerry Falwell Talks About His First Time. Jerry Falwell, for those of you who don't know, was a very larger than life, major Christian evangelical guy. He was a major, person who was very notable nationwide, and so very prominent Christian guy, preacher. And so this ad ran in Hustler Magazine about Jerry Falwell talks about his first time, and it is written in the form of an interview, which never happened. The interview never happened, but I will read you the interview that never happened. Falwell, my first time was in an outhouse outside Lynchburg, Virginia. Interviewer, wasn't it a little cramped? Falwell, not after I kicked the goat out. Interviewer, I see, you must tell me about it. Falwell, I never really expected to make it with Mom, but then after she showed all the other guys in town such a good time, I figured, what the hell? Interviewer, but your mom, isn't that a bit odd? Falwell, I don't think so. Looks don't mean that much to me in a woman. Interviewer, go on. Falwell, well, we were drunk off our God-fearing asses on Campari, ginger ale, and soda. That's called a fire and brimstone at the time. And Mom looked better than a Baptist whore with $100 donation. Interviewer, Campari in the crapper with Mom. How interesting. Well, how was it? Falwell, the Campari was great, but Mom passed out before I could come. Interviewer, did you ever try it again? Falwell, sure, lots of times, but not in the outhouse. Between Mom and the shit, the flies were too much to bear. Interviewer, we meant the Campari. Falwell, oh yeah, I always get slashed before I go out in the pulpit. You don't think I could lay down all that bullshit sober, do you? And then in fine text, it says, Campari, the Apri liquor was made to mix you up. It's light, 48 proof, refreshing spirit, just mild enough to make you think too much, to make you don't think too much before you know you're really schnockered. For your first time, mix it with orange juice or maybe some white wine. Then you won't remember anything the next morning. Campari, the mixable that smarts. And then in large text, Campari, you'll never forget your first time. And then in very small text at the bottom, it says ad parody, not to be taken seriously. Hustler Magazine printed this ad in their magazine in the 1980s. Jerry Falwell was not happy. And so he sued Hustler Magazine for libel and intentional infliction of emotional distress and many other things. The jury did not find that there was libel. The jury did not find libel, finding, at least in part, that no reasonable person could believe this to be true, but did believe that it was extreme and outrageous and intentional, and so did find the emotional distress claim. So Jerry Falwell was found to be liable for the emotional distress claim. So that case went to the U.S. Supreme Court. On this issue. And so that brings our attention to Hustler Magazine versus Falwell. Oral argument was 1987. Opinion announcement of 1988, which says the following. The lead story in the November 1983 issue of Hustler Magazine featured a parody of an advertisement modeled after an actual ad campaign. So the format, layout, and look of it was made to resemble an actual ad campaign that Campari was running at the time. So this was based on and made to look like a real ad that was actually running in reality, and they just transformed some of the elements to make it not real, but it was made to look real. So it was modeled on an actual ad campaign. The ad campaign that claimed that Falwell, who was a fundamentalist minister and political leader, had a drunken, incestuous relationship with his mother in the outhouse. Falwell sued to recover for damages for libel, invasion of privacy, and intentional infliction of emotional distress. Falwell won a jury verdict on the emotional distress claim, not the libel claim, and was awarded $150,000 in damages. Hustler appealed. The question thus presented was, does the First Amendment freedom of speech protection extend to the making of patently offensive statements about public figures, resulting in their emotional distress? So we already know, right? We've discussed this before, like with public figures, right? It's not defamation if, defamation, it's not defamation if it's true. It's not defamation. It's also not defamation if no reasonable person could believe it to be true, right? Because because then if there's no defamation is all about the false belief in the truth, or the false beliefs in the lie. So if it's so outrageous no one could believe it, it's also not defamation. That's a standard defense too. It's so outrageous no one could believe it, and no one did believe it. But so that was the standard defamation theory. But here it's like, well, look, the very thing that makes it not defamation, the fact that it's extreme, outrageous, and no one could possibly believe it, is arguably the thing that makes it intentional infliction of emotional distress, which short definition is defined as a statement or other action that is deliberately designed to cause harm in another person, emotional harm in another person. So does this qualify as intentional infliction of emotional distress? So we are going to listen to this oral argument from 1987, and then we will discuss further. This is 8 members of the court are arguing in this case. 8 members of the court are on the bench. That is because Justice Kennedy, although he had been appointed, had not yet been sworn in at the time of the oral argument. So Justice Kennedy is not here because, well, he wasn't a member of the Supreme Court yet. So we've got 8 members of the Supreme Court sitting because that's how many members of the Supreme Court were sitting at the time of the case. So we will hear from the 8 members Supreme Court in this decision. This will be fun.
We'll hear argument first this morning in number 86-1278, Hustler Magazine and Larry C. Flint versus Jerry Falwell. Mr. Isaacman, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the Court, the First Amendment protects all speech except for certain narrowly drawn categories. For example, the First Amendment doesn't protect all statements of fact made with requisite fault. The First Amendment doesn't protect obscene speech. First Amendment doesn't protect fighting words made in the presence of the person to whom the words are addressed and likely to incite violence. This case raises as a general question the question of whether the court should expand the areas left unprotected by the First Amendment and create another exception to protected speech. And in this situation, the new area that is sought to be protected is satiric or critical commentary of a public figure which does not contain any assertions of fact.
Are you suggesting that would be a change in our constitutional jurisprudence to protect that?
Yes, sir, I am. I am suggesting that. In a specific way, the question becomes, is rhetorical hyperbole, satire, parody, or opinion protected by the First Amendment when it doesn't contain assertions of fact and when the subject of the rhetorical hyperbole is a public figure? Another way of putting the question in this case is, can the First Amendment limitations, which have been set out in New York Times versus Sullivan and its progeny, be evaded by a public figure who, instead of alleging libel or instead of alleging invasion of privacy, seeks recovery for an allegedly injurious falsehood by labeling his cause of action intentional infliction of emotional distress?
Now, I love that paragraph right there because that is the sum of the case. That is an outstanding. I really, really like that because it is very true, and it's a very accurate way to frame the question. And I think it's just a brilliant way to frame the question. So, like, as I've said many times in law, and I suppose in many other fields as well, but the question you ask is often more important than the answer, because the question sort of drives your analysis, and it also drives your perceptions along the way. The very phrasing of the question influences the answer. So the precise question you ask becomes incredibly critical. And so I really like this framing of the question. It's like, okay, so how do we frame it? So it's like, okay, can the First Amendment limitations, which were set out in New York Times versus Sullivan, which deals with public figure and defamation. So we've talked about that, right? We've talked about defamation. We talked about public figure versus non-public figure. That's New York Times versus Sullivan. So New York Times versus Sullivan deals with defamation. So defamation law is fairly well established, all things considered. So it's got some parameters. So Falwell can't sue, although he tried. Falwell can't sue for libel. Because in order for it to be liable, among other things, well, it has to be a statement. It has to be a statement of fact. And if it's so outrageous, no person could believe it. It's not a statement of fact, because it is literally unbelievable. So it can't be fact because no one would believe it. So those are the parameters there. As he's saying, look, can those parameters or those limitations be evaded merely by changing the way the question is phrased? So instead of saying, okay, I'm going to sue you for libel, it's like, you can't. It's like, okay, I'm going to sue you for invasion of privacy. I can't. It's like, okay, let me try something different. Let me try suing you for intentional infliction of emotional distress. So it's like, okay, can those limitations, which were built out on defamation, be circumvented by relabeling it as an intentional infliction of emotional distress? It's an incredibly smart way to look at it, and it's a brilliant paragraph. So all the props in the world for that.
In judging the publication that's at issue here, I think it's important to look at the context in which it appeared. The speaker, of course, was Hustler Magazine. And Hustler Magazine is known by its readers as a magazine that contains sexually explicit pictures and contains irreverent humor. It takes on the sacred cows as an editorial policy. It takes on the sacred cows and the sanctimonious in our society. It focuses on three subject areas primarily. It focuses on sex, it focuses on politics, and it focuses on religion. Hustler Magazine has been the target of attacks and critical commentary by Jerry Falwell for years, and for years prior to this ad publication. Hustler Magazine is at the other end of the political spectrum from Jerry Falwell. On the other hand, Jerry Falwell, filling out the context of the speech, is the quintessential public figure. It's hard to imagine a person in this country who doesn't hold political office who has more publicity associated with his name than Jerry Falwell.
Yeah, pretty much. Jerry Falwell this time is about as public figure as it gets. He is incredibly notable. So yeah, he's very public figure. Yeah, he's up there with like Rush Limbaugh in terms of like non-political actors. Yeah, he's an incredibly notable figure, very much so. So general purpose public figure, I don't think anyone's going to have a problem with that.
Jerry Falwell is the head of the moral majority. The moral majority, he testified at the trial, numbers some 6 million people. It's a political organization, he indicates. It was set up to advance certain political views. One of the foremost of those views is to attack what he considers to be pornography. And to attack...
Palmera says, notable that man make you cringe like no other. I would point out the term notable doesn't necessarily imply a moral dimension. I mean, you know who he is, right? So he's notable. Yeah, notable is not a moral judgment. It's just simply saying that he's incredibly forward. He's very, yeah. So yeah, he might make you cringe, but he's very notable. That's for sure.
Kings of porn, in his words, and foremost among those kings of porn in his mind is Larry Flint. And he includes in that group others as well, such as Bob Guccione of Penthouse and such as Hugh Hefner of Playboy. The moral majority and Jerry Falwell also attack sexual conduct that they don't consider appropriate. He has spoken on the subject of extramarital and premarital sex. He doesn't approve of heterosexuals living together outside of wedlock. He also doesn't approve and condemns homosexuality. Now, these aren't private views that he has kept to himself or just shared with his family. These are views that he's gone on the political stump and tried to convince other people about. He has been known in his words, as he testified by the Good Housekeeping magazine, which did a survey, as the second most admired man in the United States, next to the president. He says that...
Well, Mr. Isaacman, is the fact that you claim Mr. Falwell as a public figure in dispute in this case?
It isn't in dispute at all, but
Well, then I guess we could move on to the arguments, because apparently your remarks are for the purpose of demonstrating that he's a public figure. Is that right?
Justice O'Connor, it's to fill out the political context, and the fact that what we have here are people who are at the opposite ends of the political spectrum, engaging in the uninhibited, robust, and wide-open debate. That New York Times
Does the state have an interest in protecting its citizens from emotional distress, do you suppose?
Clearly, the state has an interest in protecting its citizens from emotional distress.
And perhaps that's an even greater interest than protecting reputation.
I would submit that it is not a greater interest in protecting reputation, because in the area of reputational injury, libel as we know it, for example, when it's in written form, emotional distress is an element of recovery as well as damage to reputation. And reputation affects what other people think of you, and it affects what goes on in the minds of other people as well, not just the minds of one citizen. So reputation, in a sense, covers a lot more territory than emotional distress does. And the point of what I'm trying to make is that we really have people who are engaging in political debate in a way that involves vehement, caustic, and sometimes unpleasantly sharp language, as New York Times versus Sullivan used. Now, this speech is protected as rhetorical hyperbole, it's protected as satire and parody, and as expression of opinion. It is no worse.
Would this be a different case if the jury had found that the allegations could be considered factual?
It certainly would be a different case. It certainly would be a different case. We think that even in that situation, this court should find in that these allegations could no way be perceived as factual. As a matter of law, and in exercising its obligation under Bose, I think the court would have to do an independent review of the record and determine that constitutional fact. That is to say that there was no actual malice in this case, because this can't be perceived. Just as in Letter Carriers versus Austin, calling the plaintiffs there a traitor to their God, their country, their family, calling them, saying they have a corkscrew soul, and saying that instead of a heart they have tortured principles, was considered by this court to be rhetorical hyperbole and not to be taken literally. Similarly, there's nothing in this ad parody that can be taken as a statement of fact. And we're in an unusual situation where a jury has made that determination for us. So we now know that even this jury, which should never have been allowed to consider this.
Do you think that finding by the jury is open for this court to consider again de novo?
No, we don't think it is. We don't think it is because
I thought you were suggesting that in the First Amendment context we have to consider those issues again.
Justice O'Connor, I suggest that in the First Amendment context, when a determination is made by a jury that's adverse to speech, and when a jury finds that the speaker made statements that could be construed as statements of fact and were knowingly false, then it is incumbent upon the court to take that review for the purpose of protecting the speaker. And that's what the First Amendment says, is you have to protect the speaker.
You think Bose is a one-way street, then?
Your Honor, I do think it's a one-way street. Bose is intended to protect the speaker. It's not intended to protect the emotional distress interest that the state is seeking to protect in the area of intentional infliction of emotional stress or in the area of libel. And not only that, but we have a situation where there hasn't been an appeal from the determination in the jury. So that's res judicata here.
This is all matter that isn't really directly involved in your case. I mean, you have a favorable determination from the jury.
Yes, sir. That's correct. Now, going on, and we not only have the example of letter carriers, but we have the example of Greenbelt versus Bressler, where the plaintiff in that case was accused of being engaged in blackmail. And the court said that that can't be taken literally because that was just intended to describe his negotiating position. And that is hyperbole. And we have ample lower court precedents on the subject, such as the Pring case, which was a Penthouse article about a Miss Wyoming which attributed certain sexual activities on her part, and she sued for libel, intentional infliction of emotional distress, and other causes of action. And the 10th Circuit, after an adverse jury determination to Penthouse, the 10th Circuit reversed and dismissed that case, saying that that's rhetorical hyperbole. That article couldn't be perceived as describing actual facts about the plaintiff in that case or actual events in which she participated. Same finding that the jury made in this case. And the court then went on to say that since it's rhetorical hyperbole and protected by the First Amendment against the libel claim, it's also protected against an intentional infliction of emotional distress claim, which there was called outrage under Wyoming law, because the same constitutional defenses apply. And earlier this year in the First Circuit, in the L.L. Bean case versus Drake Publishers, the court there said that parody is protected speech. And even though the plaintiff in that case complained about the sexual parody that occurred of L.L. Bean's catalog, that was protected speech, and that case was found in favor of the speaker in that situation. Beyond that, Jerry Falwell, as a public figure, should not be permitted to evade the First Amendment limitations that have been set forth in New York Times versus Sullivan and many, many other cases with respect to his claim for an allegedly injurious falsehood. The California Supreme Court recently, through Justice Mosk, determined in Blatty versus New York and said that in Blatty versus New York Times that where the gravamen of a complaint is allegedly injurious falsehood, it doesn't matter what you call your claim, because the First Amendment covers that area.
Mr. Isaacman, what?
And I think there's something very true about that. It doesn't matter what you call your claim, because I think it speaks to this larger point, which in law, as in other things, I assume, but the label is not the thing. You know, this is not a pipe. This is just a picture of a pipe, that kind of thing. But in law, we don't really do magic words. We don't really do magic sayings. The words only have value because they are a shorthand for the thing rather than being the thing itself. So it doesn't really matter what label you put on it. It matters more about what it is. So it's like you're taking this thing and you're putting different labels on it, but fundamentally it's the same thing. A rose by any other name would smell just as sweet. And so the concern here, of course, is as you're trying to change the label of the thing, you're trying to change the protections by saying, well, this is or is not that thing. Now, something, of course, can be more than one thing at the same time, but if you're merely just changing the label, it doesn't change what it is. So there's a lot there. Every sovereign citizen disagrees with you. I know the sovereign citizens disagree with me, and this is the major problem of the sovereign citizens. The sovereign citizens believe that the law works by magic words. They believe if they just use the right words and the right intonation and the right order, then they will be protected, which is not right. That is not right. The sovereign citizens believe in law by magic words. They are very much wrong. So yeah. And they keep wondering, they seem to believe that law is magic, and if they just say the right leviosa, not leviosa, if they just say it with the right intonation, that's not really how law works, man.
What the New York Times rule provides is not an absolute protection, but a knowing element, an element of specific intent to create a falsity. It doesn't give an absolute privilege to state falsehood. It just says the falsehood is okay unless there's an intent. Now here we have a state tort that is specifically an intentional tort. There must be an intent to create the emotional distress. So it really is not quite the same category of opening up that you're making it out to be. It seems to me, it's just the issue is whether the intent element that's enough to provide a major exception from New York Times is also enough to make a major exception for purposes of this tort action. Isn't that right?
Well, Justice Scalia, we have a lot of cases, including New York Times versus Sullivan, including Garrison versus Louisiana, that say it's not the intent to cause harm, it's not the hatred, it's not the ill will, it's not the spite that the First Amendment is directed as. It's intent to cause harm through knowing falsehood or reckless falsehood.
I think that's fundamentally fair, and that also goes back to like the idea about intentional infliction of emotional distress as well, right? It's not intentional infliction of emotional distress if you're communicating something that is fundamentally true. Sort of the classic example of intentional infliction of emotional distress that I always heard in law school, and the one that I always go back to, is intentional infliction of emotional distress is you go up to a young mother and you tell her that her child is dead and you know that her child is fine. See, it's not that you're mistaken. It's not that you're confused. That you know it's false, right? And so that is just like too much. But of course, if it's true that her child is dead, then that's probably information that she needs to know, right? So the falsehood becomes a huge component of the intentional infliction. It is the outrageous nature. The outrageous nature of it is built into the character of the communication as its truth value, rather than its outrageousness and its shockingness. Because sometimes true things are shocking, and sometimes those have to be communicated. So the falsehood becomes a huge component of the intentional infliction.
The fact that in Garrison versus Louisiana is a perfect example.
I understand you can draw the line there. All New York Times says is if you state falsehood with knowledge of the falsehood, intent to be false, the First Amendment doesn't prevent it. All I'm asking is why can't that principle be extended to say you can cause emotional harm to your heart's content, but where just as you can state falsity to your heart's content, but where you intend to create that emotional harm, we have a different situation. Isn't that a possible line?
I don't think that any reasonable reader of any of the speech that has occurred in the cases including New York Times versus Sullivan, Garrison, and all the other cases that have come down, letter carriers, I gave an example, could ever say that the speaker did not intend to cause harm. When you say something that somebody has a corkscrew soul and has tortured principles for a heart and is a traitor, who can believe that person doesn't intend to cause harm? People intend the natural consequences of their actions. And they intend, when they say something critical, that they intend that that's going to cause some harm or some distress. So that's not, and that speech has to be protected, or all we're going to have is a bland, milquetoast kind of speech in this country.
That may well be. My only point is New York Times, it seems to me, doesn't speak to it. New York Times says intent is okay, is enough to get you out of it. What you're saying is this kind of intent shouldn't be enough. Intent to cause harm shouldn't be.
Intent, that's correct. Knowing falsity may be enough.
Well, but even in the New York Times sense, if what the asserted facts here were known to be untrue, I mean, one who knew nothing about Mr. Falwell or anything about the background could read this and think there might be some individual that this was a factually correct statement about. So that these are statements that were knowingly false, so they really satisfied the New York Times standard in that sense.
Justice Stevens, the response to that is really that there were no facts asserted.
Well, I understand what your argument is, but to the extent that there are factual statements, they satisfy the New York Times standard because everybody knows they're false, including the speaker.
If you change what this article means and you say that this article is capable of being interpreted as an assertion of fact, then you've kind of set the stage differently from what it is and from what the jury determined. If you say that in letter carriers that the person who made that comment was really saying...
All I'm suggesting is pretty much the same thing Justice Scalia is. I'm not sure New York Times speaks to the problem we have before us in this case.
It speaks in the sense that a knowing falsity or reckless falsity is required, and that requires that there be a false statement of fact. And the cases indicate that. Garrison indicates that. Letter carriers indicates that. Before there can be a false statement of fact, there has to be a false statement. Without a false statement, there can be no false statement of fact.
Well, that gets us back to Bose and whether we have to re-examine this statement for ourselves to determine whether it's a factual statement.
Bose was such a fucking stupid case. I can't believe it made it to the Supreme Court in some ways. Bose dealt with the speaker company who were upset the Consumer Reports was a little bit less than fully accurate in their description on how one of their speakers worked. These Consumer Reports in their description said, oh, the sound bounces around the room. And Bose is like, no, it doesn't. It just bounces off walls. And that basically became a U.S. Supreme Court case about whether or not Consumer Reports could be sued because they were a little bit inaccurate in their description. Unsurprisingly, Consumer Reports won, but I thought it was a fucking stupid lawsuit. Shit.
Well, that brings me back to my response, Justice O'Connor, that if there were an adverse determination to the speaker, this court would have an independent obligation to examine. Now,
I don't think Bose spelled it out that way. I don't read that necessarily into Bose, so you may be asking us to move on to another step beyond that case.
Well, the only thing I would say is the only case I saw that dealt with that is Brown versus K&D Corporation, the Connecticut Supreme Court case decided August 18, 1987. And my reading of that case is that the independent review goes one way, and it goes to review the adverse determination against the speaker. It doesn't go to review a finding that there was not...
I suppose that Connecticut case isn't binding on us.
That's correct. That's correct.
Well, even accepting what the jury found, that there was no reputational injury here because it wasn't a believable... was no believable fact asserted. Even
Baron White, baby.
For you to win, you have to
Haven't heard that voice in a while. Baron White. Yeah, he's an interesting character. Interesting justice.
That opinion or parody is never actionable, even though it's done intentionally for the purpose of inflicting emotional distress. You have to, that's your proposition, isn't it?
Well, Justice White,
isn't it or not?
No, it's not. As you stated, Your Honor, no, it isn't.
Well, what is it then?
Because what that leaves out is opinion or parody that does not contain anything that can be reasonably understood as a statement of fact.
All right. Yeah, but that goes... I agree with that because that's what the jury found.
Okay, and
go ahead.
Second thing that your hypothetical left out, or your proposition left out, was that this is a public figure who is bringing this action, somebody who has supposed to have a thick skin.
All right. But include that, and then you say parody or opinion about a public figure is never actionable, even though it's done intentionally for the purpose of causing emotional distress. That's your proposition.
And even though it contains nothing that can be understood as a false statement of fact.
Sure.
Including that, I agree, yes. That's my proposition. You cross the line when you can say something that can be understood as a false statement of fact. Otherwise, you're not going to have the uninhibited robust...
Well, I take it that certainly it's arguable that we must judge this case on the basis that there was no fact involved. Is that you say the jury said there wasn't?
The jury said there was nothing that could be perceived, could be understood as a fact.
Well, if we judge the case on that basis, then your proposition is that there can't be any liability here at all.
That's correct.
If there's a public figure involved. I don't know why. Would you say if there wasn't a public figure involved that we could sustain this judgment? Let's assume it was not a public figure. No believable or nothing that was said that could be interpreted as a fact. And so there would be no liable, no reputational injury. If there was not a public figure involved, you would say the judgment would stand or not?
Well, fortunately, that's not my case, but I will answer that. We don't have to deal with that case in resolving this one.
Well, you haven't answered it yet.
I would say that if it is not a false statement of fact, it does not contain a false statement of fact, or something that can be perceived as a false statement of fact, then even if it's a private figure, it's protected speech.
At common law, I suppose the exception was just for fair comment, wasn't it?
At common law
in this tort of emotional distress, that there was leeway for some kind of fair comment.
well, this tort of emotional distress is really such a new tort that there is, to my knowledge, not a lot of decisions on the point. And in Virginia, and I don't mean to evade your question, and I'll try to answer, but in Virginia itself, we found no case that allows intentional infliction of emotional distress cause of action in this arena. And we pointed that out in our brief, and the only case we did find was this Dameron versus Mitchell case, or Mitchell versus Dameron, that indicated that you cannot sue for intentional infliction of emotional distress when you're suing on what is considered to be an allegedly injurious falsehood that gives rise to a claimed libel action, because that would make that tort duplicative and would give the opportunity for a plaintiff to get around the First Amendment limitations.
Mr. Isaacman, you puzzle me with your answer to Justice White, and assuming there's no public figure involved, and you've admitted there's a public interest in protecting the citizenry from emotional distress. What's the public interest in protecting speech that does nothing else?
There is a public interest in allowing every citizen of this country to express his views. That's one of the most cherished interests that we have as a nation.
What view is expressed by this?
By this ad parody or your example?
Well, either one, other than something that just upsets the target of the comment.
What view is expressed by the ad parody is really a couple-fold view, two views or more. In the first place, we have to understand that we're talking about one page out of 150-some pages in the magazine, so it's not a treatise or a novel that's gone into a long development. It is a parody of a Campari ad. Number one, it does that. And that's a legitimate view for it to express. And we all can understand how it parodied the ad. It is also a satire of Jerry Falwell. And Jerry Falwell is in many respects a perfect candidate to put in this Campari ad, because he's such a ridiculous figure to be in this ad. Somebody who has campaigned against alcohol, campaigned against sex and that kind of thing, sexual behavior outside of wedlock.
Is the public interest that you're describing, you're building up here, that there's some interest in making him look ludicrous, or is it there is just public interest in doing something that people might think is funny? What is the public interest?
There are two public interests. With respect to Jerry Falwell alone, there are two public interests. One is there is a public interest in having Hustler express its view that what Jerry Falwell says, as the rhetorical question at the end of the ad parody indicates, is BS. And Hustler has every right to say that somebody who's out there campaigning against it, saying don't read our magazine and we're poison on the minds of America, and don't engage in sex outside of wedlock, and don't drink alcohol, Hustler has every right to say that man is full of BS. And that's what this ad parody says. And the first part of the ad parody does, it puts him in a ridiculous setting. Instead of Jerry Falwell speaking from the television with a beatific look on his face and the warmth that comes out of him and the sincerity in his voice, and he's a terrific communicator, and he's standing on the pulpit and he may have a Bible in his hand. Instead of that situation, Hustler is saying, let's deflate this stuff, sure. Let's bring him down to our level, or at least to a level where you will listen to what he has to say. I was told not to joke in the Supreme Court. I really don't mean to do that.
But that's the answer to the first half of my question. What's the public interest?
Bring him down to our level. That's cute. Yeah, that's cute. I like that. Got a big laugh out of that one, man. Got a big laugh. Nice. Can I explain what common law is? Not easily. No. Common law is the decisions of the courts over the last 800 years. Is common law. It's the interpretations and the judgments of the courts over the last 800 years. It is the judge-made law. That's the short definition. It's no much way I can say it much shorter than that. That's about as good as it's going to get.
In the case involving a private figure.
In case of a private figure, the public interest is admittedly less. There is still an interest in expressing your views, and there's still an interest in people being able to express their views, apart from the fact that the public may not have any great interest in hearing those views.
Mr. Isaacman, to contradict Vince Lombardi, the First Amendment is not everything. It's a very important value, but it's not the only value in our society, certainly. You're giving us no help in trying to balance it seems to me, against another value, which is that good people should be able to enter public life and public service. The rule you give us says that if you stand for public office or become a public figure in any way, you cannot protect yourself or indeed your mother against a parody of your committing incest with your mother in an outhouse. Now, is that not a value that ought to be protected? Do you think George Washington would have stood for public office if that was the consequence? And there's no way to protect the values of the First Amendment and yet attract people into public service? Can't you give us some line that would balance the two?
Well, one of the lines was suggested by a question earlier, and that is in the private figure, public figure area, if the court really wants to balance. But somebody who's going into public life, George Washington is an example. There was a cartoon in, I think it's the Cartoonist Society brief, that has George Washington being led on a donkey, and underneath the caption is something about George so-and-so who was leading the donkey is leading this ass, or something to that effect.
Now, I can handle that. I think George could handle that. That's a far cry from committing incest with your mother in an outhouse. I mean, there's no line between the two. We can't protect that kind of parody and not protect this.
There's no line in terms of the meaning, because Hustler wasn't saying that he was committing incest with his mother. Nobody could understand it to be saying that, as a matter of fact. And what you're talking about, Justice Scalia, is a matter of taste.
Good answer. Good answer. There is no line, because no one understands it to be true. No one understands it to be true. And then, okay, so if there's nothing objective that we can put our teeth into, right? If we can't say it's a false statement that is outrageous, if we don't have that objective element, the falsehood, right? If all we're looking to is the subjective of this is outrageous, well, what makes it outrageous? And, is just mere perception and mere taste about what is or is not outrageous. And it's like, well, is that really where we want to go? And it's just a matter of taste. It's a great answer.
And as Justice Scalia, as you said in Pope versus Illinois, just as it's useless to argue about taste, it's useless to litigate about it. And what we're talking about here is, well, is this tasteful or not tasteful? That's really what you're talking about, because nobody believed that Jerry Falwell was being accused of committing incest. The question is this in good taste to put him in this, draw this image, paint a picture?
Charge.
If you charge a man with a crime, Your Honor, and it's an assertion that he committed a crime.
Against a public figure, it's okay.
No. If a knowing false statement of fact, if you're charging him with a crime and it's perceived that you're charging him with a crime and you're doing it with knowledge that that's false, it's not okay against a public figure.
Isn't that this case?
No, it isn't this case, because he's not...
You say they didn't charge him with incest?
Justice Marshall, they did not charge him with incest, and the jury determined...
Why did they have him and his mother together?
They had him and his mother together to what's called in literary form travesty, to put somebody in a ridiculous, unbelievable setting for purposes of effect. They put him in this situation knowing nobody would really perceive that that's what he's actually doing. But to say we're going to deflate this man who is so self-righteous in the area of sex and telling everybody else what to do, as well as telling them what to read.
And what public purpose does that serve?
What it does is it serves the same public purpose in a sense of having Trudeau and Doonesbury call George Bush a wimp.
Yeah, I like that answer too. It's like, Even in the modern parlance, in the Doonesbury cartoon, they had a cartoon calling George Bush a wimp. And it's like, well, that's an opinion. That's the opinion of the cartoonist. And so, you know, it's to be provocative, I suppose. But yeah, it's an opinion. So Hustlers magazine is an opinion more colorfully presented, perhaps, but an opinion nevertheless. Public purpose doesn't need to have a purpose. Yeah, kind of. How would you say this in a way that makes sense? There needs to be a purpose behind it that is good for the public order, for it to be something that society is prepared to protect. Right? If this has no value to society, if this has no value to the good of the order, then why are we as a society protecting it? So individual rights, generally speaking, are valuable not because, well, they're valuable because they protect the individual, but they're also valuable because they protect the public at large. Because what is the value in something like the Fourth Amendment? Why do we not want to have the police come down and search anyone's home anytime we want? I mean, that would presumably allow the police to discover more evidence of more crimes, right? So why do we not want to have the police, you know, go into anyone's house at any time we want and search for whatever they want and find whatever they want? Presumably we would find more crimes. Presumably we would arrest and charge more people for bad things they actually did do. But the value in it is that, well, we don't want to have that kind of society. We don't want to have that kind of society. We all want to have the ability to be secure in our own privacy. So that's an example. And also the First Amendment, like, what is the value in one person speaking? Is that the person can speak? Is that everyone can speak? The value in one person speaking is that everyone can speak. So it's like, if it has no redeeming purpose, then the law is probably not going to protect it. So yeah, there's definitely something to be had there.
What public purpose does that have? It makes people look at that and think of George Bush a little bit differently. And somebody who is out there telling other people how to live and being very serious and sober about it and acting as though he has more knowledge than they do about how they live their lives, Hustler has a right to make comments about it and make him look ridiculous as long as they don't state false statements of fact knowingly or recklessly.
Well, it was a false statement of fact that he was in the outhouse with his mother. That was a false statement of fact.
It was not a statement of fact, Your Honor, and the jury so found it. What was it? It was hyperbole, just as calling somebody a blackmailer was not saying he's a blackmailer. It was saying that he was engaged in...
If you charge somebody with saying, if you don't pay me money, I'll report you, that's blackmail.
That's correct.
Well, that's the same as this was.
That's correct. But in Greenbelt, saying that somebody was a blackmailer...
You mean they had to say that he was guilty of incest? In quotes.
Thank you, Mandy, for becoming an uncivilian.
They had to say it. No, it is not right, Your Honor.
How close would they have to get to that?
They would have to say it in a way that a reasonable reader would perceive that that's what Hustler was saying, that he is guilty of incest.
Yep, this response is correct. Because Justice Marshall, Thurgood Marshall, Holla, is basically saying, is this a magic words problem? Do they have to say guilty of incest? Do they have to use the words? Is that the issue, that they have to use the precise words? And if so, how close do they have to get to it? And Alan Isaacman's response is better. His response is better than Thurgood Marshall's question. It's like, no, this is not an issue of magic words. It is not that Hustler didn't say this phrase or did say this phrase. They could have literally written Jerry Falwell is guilty of incest, and that wouldn't necessarily be the end, because the question isn't the words that are used. And you should know this from defamation, right? It isn't, you can't just say, in my opinion, as magic words. You can't just say, you can't just use magic words to get out of what is understood and what is being conveyed. So the question is, what would the reasonable reader understand, and would the reasonable reader understand it to be a statement of fact? Are you in fact making a factual claim? And in this situation, no one's understanding it. So they could have used different words or alternate words and still no. So his answer is better than the question. So I appreciate that.
And this jury, who was certainly not a jury that came from Hustler's background in any way, said that no reasonable reader could perceive this as a statement of fact. And in summing up, what I would like to do is saying this is not just a dispute between Hustler and Jerry Falwell, and the rule that's applied in this case is not just that Hustler magazine can no longer perform what it does for its readers, and that is produce this type of irreverent humor or other types of irreverent humor. It affects everything that goes on in our national life. And we have a long tradition, as Judge Wilkinson said, of satiric commentary. And you can't pick up a newspaper in this country without seeing cartoons or editorials that have critical comments about people. And if Jerry Falwell can sue because he suffered emotional distress, anybody else who's in public life should be able to sue because they suffered emotional distress. And the standard that was used in this case, does it offend generally accepted standards of decency and morality? There's no standard at all. All it does is allow the punishment of unpopular speech.
How often do you think you're going to be able to get a jury to find that it was done with the intent of creating emotional distress? I mean, there was that finding here.
Every time, almost every time that something critical is said about somebody, because how can any speaker come in and say, I didn't intend to cause them emotional distress, and be believed? If you say something critical about another person, and if it's very critical, it's going to cause emotional distress. We all know that. That's just common sense. So it's going to be an easy thing to show intent to harm. That's why that's a meaningless standard. Incidentally, it was a negligent standard in this case.
Thank you, Mr. Isaacman. We'll hear now from you, Mr. Grudman.
Nice. I like this. I also liked it when the Supreme Court was tighter in its time limits. You know, a half hour was a half hour. I liked it. In the more modern, they go to this more open question format and it takes longer. I liked it when a half hour was a half hour, man. Let's listen to what Hustler has to say as part of their argument. Or apologize. Let's listen to what Falwell has to say as part of their argument. So we heard from Hustler. Let's hear from Falwell.
Mr. Chief Justice, may it please the Court. Deliberate, malicious character assassination is not protected by the First Amendment of the Constitution. Deliberate, malicious character assassination is what was proven in this case by the defendant's own explicit admission. The publication before this Court was the product of a deliberate plan to assassinate, to upset the character and integrity.
This guy has a great voice. This guy has a great voice.
Of the plaintiff, and to cause him severe emotional disturbance with total indifference then and now to the severity of the injury caused. When the publication was protested by the bringing of this lawsuit, the unregenerate defendant published it again. Justice Scalia, I'd like to answer a question that you raised with my adversary. How often are you going to be able to get proof like this? I dare say very infrequently, and I dare say that the kind of behavior with which the court is confronted is aberrational. This is not the responsible publisher. This is the wanton, reckless, deliberately malicious publisher who sets out for the sheer perverse joy of simply causing injury to abuse the power that he has as a publisher.
Mr. Grutman, I guess there are those who think that the conduct of certain newspapers in pursuing Mr. Hart recently was of the same unwarranted character.
Just as a
should that result in some kind of liability?
I don't think so in that case, because what was being done by the newspapers in that case was reporting the truth about a public figure who was a candidate for public office. The context in which the publications about Gary Hart appeared cannot really be compared favorably with what was done here.
So you would limit the recovery for the tort of emotional distress to recovery for a falsehood?
No.
No.
Under the theory of the intentional infliction of emotional distress, even the truth can be used in such a way, if it is used in some outrageous way, it must be something which is so repellent.
And what if the jury were to determine that what the newspaper did with regard to Mr. Hart fell in that category? Is that recoverable?
If the jury were able to find from the evidence, Justice O'Connor, that the publication was outrageous, I would doubt that they would find that, because it is not that kind of conduct, reporting the truth.
But you would say it's open to a jury determination.
Only in a highly theoretical sense, if the animating purpose behind the publisher was simply to inflict intense and severe emotional distress upon Gary Hart. But I think that's really not the issue. The focus in this tort, which is not the tort of libel, the focus is on the harm which is inflicted on the victim.
Well, do you think a vicious cartoon should subject the drawer of that cartoon to potential liability?
Only in the event that the cartoon constitutes that kind of depiction which would be regarded by the average member of the community as so intolerable that no civilized person should have to bear it. That's the definition of the
Well,
tort.
Mr. Chairman, you're certainly posing a much broader proposition than is necessary for you to win this case.
It's like, you're asking, it's like maybe you're asking for too much. Be careful.
Indeed, but I was answering the question of Justice O'Connor.
Well, the way you put it from the very outset, you put it the same way. We're judging this case on the basis that the jury found that no one could reasonably have believed that this was a statement of fact. And that's the way we judge this case.
No, I'd like to address that point, Justice White, because I think a kind of semantic conundrum has been presented here when counsel says that there was no statement of fact. There was a statement of fact. Just as we argued in our brief, you could state gravity causes things to fly upward. That is a statement of fact. It's just a false statement of fact. And if one consults the...
See, no, I think the problem there is it's confusing form over substance. That's the problem, right? That's the problem. It's confusing form over substance. And the law, generally speaking, focuses much more on substance than form. It's like, if you say gravity causes things to fall upward, well, is that a statement of fact? Or if you say, in my opinion, gravity causes things to fly upward, is that necessarily an opinion? So it's like, yeah, no, not necessarily. Just saying gravity causes things to fall upward. If it's not understood as a statement of fact, if it's not presented as a statement of fact, if the viewer or listener or reader wouldn't understand it to be a statement of fact, it's not a statement of fact. And so the form doesn't dictate what it is. So yeah, elevation of form over substance, it's a mistake.
What do you make out of the special verdict the jury returned?
I make out of it the fact that the jury said that this was not describing actual facts about the plaintiff or actual events in which the plaintiff participated. That is a finding that what the statement was in the publication was false. Perhaps we should have appealed that. That's a finding of falsity, which is all that we needed to prove to sustain libel. But we did not appeal that. That question is not before the court. But in answer to your question, I find that the meaning of the answer to that question only goes to the issue of whether the jury thought that Reverend Falwell...
I don't know why you insist on this, because if it's not, if there's anything factual about this statement, you certainly have to contend with New York Times. And if there's nothing factual about it, you don't have to contend with it at all. All you have to say is, or all you have to win, which is plenty, that and using opinion or parody to inflict emotional distress is not protected by the First Amendment, which is a considerably different proposition than what you've been pushing.
I agree that parody or so-called satire, whatever it calls itself, is not necessarily protected speech where the purpose of the publisher is to inflict severe emotional distress. And while the contention is made in the argument that you've heard this morning that this was a parody, I think that the jury could properly examine this and recognize it for what it is. A fig leaf isn't going to protect this kind of a publication from being recognized as the kind of behavior with which the tort of the intentional infliction of emotional distress is intended to deal.
And I agree with that too. Like, just because they say this is a parody doesn't necessarily make it true either, right? Just because they wrote at the bottom of this is a parody not to be taken seriously, I don't think necessarily is the thing either, because that also would be the elevation of form over substance. It's like, if you're like, nothing I should say should be taken seriously. But it's clear that you intend to be taken seriously, which can be understood from a whole lot of other contexts. And So I agree the fig leaf isn't going to do the thing. That's certainly true.
But you would subject, though, the range of political cartoonists, for example, to that kind of jury inquiry.
No.
Whether it was vicious enough to warrant recovery.
Two things must conjoin. What you have to have is an irresponsible intention on the part of the defendant to inflict injury. That's only one half of it. The other is that what the cartoonist, the writer or the speaker does constitutes in the mind of the community an utterance of such enormity, such a heinous kind of utterance, usually false.
Usually false.
Have to bear that if the purpose was to inflict severe emotional injury, and severe emotional injury results.
Usually false. Usually false. And that's a problem. Usually false. The true things, man, you're entering into a world in which there's a potential for true things. That's a problem.
A cartoonist who sits down at his easel, or whatever cartoonists sit down at, and thinks to himself, candidate X for the presidency is just a big windbag, a pompous turkey, and I'm going to draw this cartoon showing him as such. Part of his intent, he enjoys cartooning and just likes to make people look less than they are, to show up the dark side of people. But he knows perfectly well that's going to create emotional distress in this particular person. Now, does that meet your test?
No, because it does not, unless what he depicts is something like showing the man committing incest with his mother when that's not true, or molesting children, or running a bordello, or selling narcotics.
But what about the state of mind required?
I like the juxtaposition of those things. I will leave it to the reader to decide whether or not those are equally in magnitude. But having incest with your mother versus molesting children versus running a bordello, which is to say running a whorehouse, versus selling narcotics. I'm not sure those are all equally outrageous, but he equates them, or at least is comparing them. So notable.
From the defendant.
Well, the state of mind is precisely what we are concerned with.
Well, but what about the state of mind I've hypothesized to you? Does that satisfy your test for the Constitution or not?
It would not. If the man sets out with the purpose of simply making a legitimate aesthetic, political, or some other kind of comment about the person about whom he is writing or drawing, and that is not an outrageous comment, there is no liability.
Even though he knows it will inflict emotional distress?
It has to be correct, because you cannot have emotional distress for mere slights, for the kinds of things which people in an imperfect world have got to put up with. Calling somebody some of the epithets that were mentioned in the opposing argument, blackmailer, or some other conclusory and highly pejorative term, is an epithet. But when you say, not that you are some foul conclusory term, but when you depict someone in the way in which Jerry Falwell was depicted, with all of the hallmarks of reality, including the pirated copyright and the pirated trademark, so that the casual reader looking at it could think that this is for real, That rises to the level of what...
That's a different
Yeah,
argument now.
that doesn't go to the question of intent. What about a case in which another magazine publisher today decided, I think I could sell a lot of magazines by reprinting this very parody here because it's gotten so much publicity and some people may think it's funny and so forth. I don't care if it hurts Mr. Falwell, but it will cause precisely the same harm as this one. Is there recovery in that case or not?
I do not think so, or I think it's a much
So it's
harder
free
case.
game now. Anybody can publish this other than Mr. Flint.
Justice Stevens, Mr. Flint republished it for a third
I
time
understand.
after the jury verdict.
What you're telling me is, under your test, anybody else may publish it without incurring liability.
Liability requires an intent.
But you do agree with what I say?
I do, Mr. Justice Stevens. I agree that intent, this is why this is such a rare tort. This is, as I've suggested, an interstitial tort.
Mr. Grubman, you've given us a lot of words to describe this. Outrageous, heinous,
Repulsive and loathsome.
repulsive and loathsome. Oh, I don't know, maybe you haven't looked at the same political cartoons that I have, but some of them, you know, and a long tradition of this, not just in this country, back into English history. I mean, politicians depicted as horrible-looking beasts. And you talk about portraying someone as committing some immoral act. I would be very surprised if there were not a number of cartoons depicting one or another political figure as at least the piano player in a bordello.
Justice Scalia, we don't shoot the piano player. I understand that.
Well, but can you give us something that the cartoonist or the political figure can adhere to, other than such general words as heinous and whatnot?
Yes.
I mean,
I think
does it depend on how ugly the beast is, or what?
It's not the amount of hair the beast has or how long his claws may be. I believe that this is a matter of an evolving social sensibility.
Ooh, not a good argument with Scalia. Not a good argument with Scalia. It's a matter of evolving social sensibility, you say to Scalia. Oh, okay. So things that are in the past are not okay, and things in the future are different. Oh, okay. It depends on how society evolves or doesn't evolve. So the cartoonist liability depends on the winds. And of course, you say society like it's one thing, which of course it's not, especially in a nation both geographically and culturally as diverse as the United States. It's as big as Europe, man, and probably as diverse as Europe in most dimensions. So yeah, this is not great. First of all, you're floating. And second of all, no, I can't give you anything concrete. Depends on what people think at the time. That's definitely going to be a great argument to go with for Scalia, sure.
Between the 1700s and today, I would suggest that people have become more acclimatized to the use of the kinds of language or the kinds of things that are depicted that in an earlier age would have been regarded as socially unacceptable. And while that evolutionary change is taking place, and it's a salutary thing, there are certain kinds of things, it's difficult to describe them. This court struggled for years to describe or put a legal definition on obscenity, and Justice Stewart could say no more than, I know what it is when I see it. Well, this kind of rare, aberrational, and anomalous behavior, whatever it is, whatever the verbal formulation that the nine of you may come upon, clearly it can be condensed in the form of words that I used, which are not mine. They belong to the oracles of the restatement, who have tried to say that it is for the jury to decide whether or not what is being depicted is done in so offensive, so awful, and so horrible a way that it constitutes the kind of behavior that nobody should have to put up with.
Well, Mr. Grutman, in today's world, people don't want to have to take these things to a jury. They want to have some kind of a rule to follow so that when they utter it or write it or draw it in the first place, they're comfortable in the knowledge that it isn't going to subject them
I frankly
to a
think it
suit.
isn't too much to expect, Justice O'Connor, that a responsible author, artist, anyone would understand that attempting to falsely depict as a representational fact that someone is committing incest with his mother in an outhouse and saying that she's a whore, and that where the person involved is an abstemious Baptist minister, that he always gets drunk before he goes into the pulpit, it isn't too much to say that anybody who would do that ought to take...
Oh dear, special pleading. Oh dear. This is not a good argument. He's can't define the set of cases. And basically his argument is it's okay. It's just this one time. Just this one time, Your Honor. This is obviously so outrageous, so clearly outrageous, so beyond the pale that you don't need to worry yourself. You don't need to worry yourself with setting some sort of universal standard. This is so clearly beyond the pale that there's no need to worry about any sort of universal rule or something. I mean, it's just so clear. It's so obvious, and every artist will just be clear and it'll be obvious. It'll all be fine. Don't worry about it. Don't worry about what happens next, he says to the U.S. Supreme Court. Holy shit. Yeah, that's not a good moment. That's not a good moment right there. Don't do that.
The consequences for casting that into the stream.
Well, that's the way you put it.
That's the way they
don't need any new rule of law for that. New York Times wouldn't insulate any statement of fact like that.
Justice White, I don't think this case is governed by the New York Times rule. When I tried this case, we were living in the heyday of Gertz, and we had not yet had this court's decision in Dun & Bradstreet or in Philadelphia newspaper versus Hepps. I would suggest to this court that we are covered by your decisions in those cases. This is not speech that matters. This is not the kind of speech that is to be protected. The New York Times rule is not a universal nostrum. It is a rule that you formulated to meet a constitutional crisis in which truth is relevant here.
If these were factual statements like you mentioned, New York Times you could win under New York Times anytime.
Yes, we could win under New York Times, but I am suggesting that as a jurisprudential matter, the New York Times formulation of actual malice is inappropriate and irrelevant for this tort, for the reason that when you're dealing with the tort of libel, the focus of inquiry is on the gravamen, is on the issue of truth or falsity, in which facts become the measure of what is truth or false or something which has been dealt with recklessly. The gravamen of this, as I say, interstitial tort is on the harm that was inflicted on the victim.
Interstitial is also not great, just as an argument. Just, this is a tort that exists in the gaps. So it's a tort that's defined by other torts. It's a tort that's defined by the space between other torts, rather than having a definition into itself. It's a gap filler, your argument, Your Honor. It's like the second or third time he said the word interstitial. I'm like, I don't know, man.
And the constitutional measure here is intentionality. It's what this court said in the dissent of Chief Justice Rehnquist. We're really dealing with, whether you call it scienter or mens rea.
Well, Mr. Grutman, there's plenty of malice here, all right. I mean, I don't think that's your problem. But the jury said this can't be reasonably viewed as making a factual allegation.
No, I disagree, Justice O'Connor, and if you'll give me a moment, that is what is the easy way of looking at it, but that's not what they said. The question answered is, can this be understood as describing actual, meaning truth, actual facts about plaintiff, or actual events in which plaintiff participated? And they said no. That to me means that they said this is not a true statement of fact, but it's nonetheless a statement of fact for the purposes of New York Times or for the purposes of this case.
Give me a statement that isn't a statement of fact. Give me a statement that isn't a statement of fact in your interpretation of what statement of fact means. I mean, when you say statement of fact, I think it means true fact, or it means nothing at all.
No.
Give me a statement.
That is one way. That is the Aristotelian interpretation of a statement of fact as propounded by Professors Wexler and Michael in their famous monograph. But in the common parlance in which we speak, a statement of fact is an utterance about either an event or a thing or a person which can be proven either true or false. If it's true, then it's a true fact. But if it's false, like things, gravity causes things to float upward. That's a statement of fact, but it's manifestly false.
So there's no statement that is not a statement of fact, is what
That
you
is
say.
correct. However, there may be statements, that's an interesting philosophical question that we could explore endlessly.
Mr. Grutman, that's not the way the Fourth Circuit interpreted the finding in this case. They interpreted it, as I read their opinion, the majority, to mean that the jury understood it was not a statement about a factual statement about it. They didn't intimate they thought the statement was false. So you're urging on us a meaning that has not been accepted by any of the courts that have had the case so far.
Candidly, I must say that I do not think that the Fourth Circuit made the point which I first tried to make to Justice O'Connor and which I am making to you. In retrospect, I believe we could have appealed this as a proper basis for libels by virtue of that finding.
But you didn't.
Yeah, that pretty much is the end of that game. First of all, no, I don't think you could have. Second of all, we could have, but you didn't. Yeah, that's kind of the end of that game. That's over. So yeah. Thanks for playing.
I didn't, and that's therefore it wasn't before the Fourth Circuit, and it's
Not
not
only
here
that,
now.
but the purpose in the jury instruction was to ask that question as a predicate to the second question, which related to malice, which wouldn't have had any purpose to it unless it's interpreted the way your opponent.
That is the way it looks in the cold light in the Supreme Court today. I remember that at the time when those jury instructions were being fought over in the pit of the trial, it really had to do with a certain contention that Judge Turk was flirting with about the meaning of pring, as to whether or not what was done in pring constituted some basis.
Yeah, but your second question all goes to whether the New York Times malice standard, and that just isn't even implicated unless it's a false statement of fact.
Justice Stevens, I agree. Maybe I should have done something different, but I thought at the time that the damages that we were seeking to recover were equally recoverable under the theory of the intentional infliction of emotional distress.
May I ask a different question that just troubles me a little bit about the case? Your tort is one, I gather, that's founded on Virginia law. This is a diversity case, is it not?
This is a Virginia tort, like many other
The contours of this tort, presumably we would find in some Virginia decisions.
Yes.
And the latest decision that's cited in your opponent's reply brief is a lower court decision, which seems to say there's no tort of any of this kind at all.
That case, which I saw when I received their brief, I believe yesterday, I noticed was a court of inferior jurisdiction. Right. I do not think that it is controlling on this court. I do not think that it is good law.
Let me help you out. Let me help you out on that. Whether it's controlling or not. Yeah.
Correctly describes Virginia law. It is controlling. We have to, in terms of what the Virginia law is, we don't decide that.
I understand that, but I believe that there are other cases in Virginia which have been cited in our brief which support the validity of the proposition that we are asserting that Virginia recognizes this as a separate and independent tort. Now, that's a lower court case that may be appealed or it may not, but there are higher authorities within the state of Virginia which support the position that we're advancing here.
Which are cited in your brief.
Yes, they are, Mr. Justice Stevens. Now, Hustler contends that the actual malice test of libel law preempts the field and must be applied universally and literally to all dignitary torts involving speech. And I suggest that the Dun & Bradstreet decision and the Heps decision reject that. This court has not treated that as a universal nostrum. This court has recognized differences in speech and has granted less First Amendment protection and sometimes no First Amendment protection. In this case, subjective awareness of falsity or reckless disregard of truth are an appropriate way of examining actual malice when the gravamen of the tort is falsity as in libel. However, here, with the intentional infliction of emotional distress, which has also been described as outrageous conduct.
Mr. Grutman, is libel per se recognized in Virginia when you charge somebody with a crime?
I believe so.
Nobody pays any attention to that at all.
No one pays it
any attention to that fact.
In this case?
Yeah.
In retrospect, I understand what you're saying about that, Justice Marshall, but I was fighting in that case the suggestion that this was hyperbole or the expression of an opinion, and Judge Turk would not accept the view that the accusation of incest is a crime which constitutes libel per se, and so I was unable to try the case in that posture. As I was pointing out to the court, the harm done to the individual is the focus of this tort. It's not a new tort. It's been in existence for 100 years.
It's not what you said earlier, man.
A new tort when applied to the press.
It is not a new tort, because there have been cases that have been decided in a number of states in which the press has been held liable for this tort, not only for the intentional infliction.
But how recent are those cases?
Well, the Florida case that I speak of is a 1984 case.
What I said was that it's only recently, isn't it, that the courts have been bringing activities of the press within this expanding tort of intentional infliction of emotional distress.
To that extent, I agree with you, Mr. Chief Justice. This is, for this court, a tabula rasa. Not exactly.
Ooh, tabula rasa, very fancy.
Because in this connection, you are...
Ooh, terra incognita. This guy has all the fancy words. Fancy. Tabula rasa, terra incognita. Ooh, if he uses enough fancy words, maybe he'll win. Very exciting.
Has developed in constitutional interpretation, certainly over the last 23 years, when what has been described as the federalization of the law of libel first began in a commendable context and is now spread to the point where I believe you are considering either dismantling or discarding Gertz. And the reason for that is that the press that clamors here for a universal exemption so that they should have license to do what these people have done, and that it should be condoned and considered just a trivial or trifling incident of being a public figure. In Mr. Justice Powell's decision in Gertz, he talked about protecting speech that mattered. Yes, it was. But when, in the opinion that Mr. Justice Powell wrote, forgive me, Mr. Justice White, for the court,
lawyers always personalize these opinions.
Well, Mr. Justice,
they are court opinions.
I apologize to the other members of the court to whom I meant no slight, but it's an opinion I'm sure...
Of course, I was in dissent, yes.
In my view, Mr. Justice White, that dissent either is or may become or should become the law of the land.
I doubt it.
Because...
Yeah, when the guy who authored the dissent says, in response to maybe your dissent will be the law of the land, he's like, I don't think so. Yeah, it's probably not going really well. Probably not going really well.
Well, I don't know any place else to suggest that it ought to be, but I do think that what experience has shown us has been the unworkability of that rule. For example, in Time versus Hill, which was 20 years ago, footnote 7, Justice Brennan, quoting a Second Circuit case, I think it's called the SCOTUS case, said, speaking about even true revelations may be so intimate and so unwarranted in view of the victim's position as to outrage the community's notion of decency. So this is a problem that was foreseen more than 20 years ago, and now the problem is with us.
Redmond, I think it'd be a different, if there were Virginia statutes saying, it's tortious to depict someone as committing incest, then the cartoonist knows what he's up against. But just to say heinous and you just leave it to the jury. You think, for example, that it isn't only the incest that offends you. You think that portraying a Baptist minister as having taken a shot or two before he went onto the pulpit, that would qualify in your notion.
I think in that community particularly it would satisfy.
Well,
but I don't concede.
You don't think that's debatable?
All these questions are debatable. That's why they go to juries for determination. But I think it is highly unrealistic that a legislature should sit down and write a decalogue or a catalog of prohibitions to constitute guidelines for people exercising free speech. As a judge said in another case, the common law has been sufficient not to muzzle the press, and the common law is already...
Common law hasn't had this tort.
This is a common law tort. Downton versus Wilkinson was a common law tort It is a tort.
Since 1984, as applied to this field, you tell us.
No, I said in 1984, when I started to quote these cases to Mr. Chief Justice Rehnquist, there was a Florida case in 1984, there was a Missouri case in 1982, there was a case in Wisconsin in 1970, another in 1982, and there have been cases in New Hampshire, Ohio, and the District of Columbia, including one in 1929, which is Perry against Capital Traction Corporation, in which this court denied cert.
This isn't Blackstone. I mean, this is pretty new, all of it, isn't it?
The memory of man runneth contrary, perhaps, to a time when this was a tort. I think the tort originated in the early 1900s. It originated in England. It's present here. It has been a subject of the restatement first and a subject of the restatement second.
The Supreme Court isn't really buying that this is ancient. Your Supreme Court isn't really buying that this is ancient law. Yeah, they're not buying that. They're not buying that sell, man.
Perhaps it's something that becomes more prevalent in our society because of the irresponsibility of certain aberrant publishers. This is an established tort under the law of Virginia and under most of the states. And I believe that as a constitutional rule, the protection of the individual's interest in his own sense of worth and dignity and to be free from this kind of gratuitous onslaught and damage to his feelings is something that ought properly to be left to the states. Hustler and Judge Wilkinson argued that there is some new kind of category that this court ought to establish called the political public figure. That is a figure unknown in any other decision, and certainly not in this court, and I would surely argue against it, because this court has said that by becoming a public figure, a person does not abdicate his rights as a human being. And if libel will not protect someone who is subjected to this utterly, not dubious, but worthless kind of verbal assault, then the tort of the intentional infliction of emotional distress, which Virginia recognizes, is a tort which deserves support and endorsement in this case and in this court. This case is no threat to the media.
Mm-hmm.
It will be the rare case indeed where this kind of behavior will ever be replicated. But where it occurs, it deserves the condemnation which the...
This is no threat at all. This is rare, or not exactly the same thing. Yeah, no, that doesn't really, yeah.
Jury gave it, which the Fourth Circuit found, and which I respectfully submit this court should affirm. Thank you.
Thank you, Mr. Grubman. The case is submitted.
I do like it when the Supreme Court actually had hour-long oral arguments. I'm not going to lie, I do like it. All right, let's listen to the decision of the Supreme Court, something we don't often get to do because usually we're hearing oral arguments as they happen. But of course, since this one happened 40 years ago, we can listen to the oral argument. We can listen to the announcement of the decision from the bench. So we will listen to the announcement of the Supreme Court rules and their opinion. It's only 2.5 minutes long, so let's listen to what the Supreme Court had to say.
In the third of this rather long series of cases, number 86-1278, Hustler Magazine et al. Versus Falwell. Respondent Jerry Falwell, a nationally known minister and commentator on public affairs, sued petitioner Hustler Magazine and its publisher, petitioner Larry Flint, for the torts of libel and intentional infliction of emotional distress after an ad parody featuring Falwell's name and picture was published in Hustler Magazine. This ad parody also contained a fictional interview with Falwell in which he allegedly describes a drunken and incestuous encounter with his mother in an outhouse. After a trial, the jury held for Hustler on the libel claims, specifically finding that the ad parody could not reasonably be understood as describing actual facts about Falwell or actually events in which he participated. The jury found for Falwell on the intentional infliction of emotional distress claim, however, and awarded him both compensatory and punitive damages. The Court of Appeals affirmed this award, and we now reverse the judgment of the Court of Appeals. The respondent contends that the First Amendment does not prevent a public figure from recovering damages for speech that meets the requirement of the state law tort of intentional infliction of emotional distress. that is, speech that was intended to inflict emotional distress, was outrageous and did in fact inflict serious emotional distress. We think, however, that in the context of public debate about public figures, the First Amendment prohibits the finding of tort liability solely on the basis of an intent to injure or to harm. The fact that the speech at issue is outrageous is not a sufficient basis to subject it to tort liability. For if you went ahead on this basis, it would allow jurors to impose liability on the basis of their tastes or views and perhaps on the basis of their dislike of a particular expression. We conclude that in order for a public figure or public official to recover for the intentional infliction of emotional distress, you need to show additionally that the publication was made with actual malice, that is, with knowledge that it was false or with reckless disregard of whether it was false or not. Here it's clear the respondent is a public figure, and therefore he may not recover on the basis that the Court of Appeals said he could. Justice White has filed an opinion concurring in the judgment. Justice Kennedy took no part.
And as I said before, Justice Kennedy took no part because he wasn't a member of the Supreme Court at the time of the oral argument. He became a member of the Supreme Court afterwards. So there were only 8 members of the Supreme Court at the time. So 8-0 unanimous. 8-0 unanimous Supreme Court. Falwell loses. And yeah, it's a foundational case in First Amendment jurisprudence. Like, yep, basically you can't go through the back door, dunch, right? You can't go through the back door. Yeah, you tried to do this in defamation. It doesn't work in defamation. You tried to do this in invasion of privacy. It doesn't work in invasion of privacy. Can't do it in intentional infliction of emotional distress either, because it is not a statement of fact. It is extreme and outrageous, but it is part of the mockery, and it is not a statement of fact, so it doesn't fall into the definition. So, end of discussion. And yeah, as was noted in the comment, that Falwell and Flint did apparently become friends afterwards. So apparently they kissed and made up somewhere along the line. So yeah, so interesting. But I thought this was a fun discussion. It was fun going back into the archives. The movie The People versus Larry Flint has been in my YouTube feed for a little while now for some reason. I was like, you know what? We'll just go back and we'll just do the original. We'll just go back and listen to the thing. So yeah, that's it. 8-0 by the Supreme Court, and freedom of speech gets a little bit more expanded. So pretty interesting stuff. I know there's not many of you here, but if there's anyone here, if they have any questions, we can do some questions. But yeah, seems like obvious parody. Well, it does now. Seems obvious now because it's been 40 years, right? So 40 years later, it seems pretty obvious. Although at the time, and the Fourth Circuit went the other way. The Fourth Circuit said no. The Fourth Circuit, the trial court found for Falwell. The Fourth Circuit Court of Appeals found for Falwell. Supreme Court went the other way and said no. So maybe less obvious to some. What's my favorite Scalia quote? I really liked when Scalia was testifying before Congress, and he talked about the structure of the Constitution and the importance of the structure of the Constitution. I really liked that little discussion that he had. It was good. And I also liked it when he schooled, it was, who was it? It was one of the senators from California, and he schooled her on the 14th Amendment, I think it was, and how it didn't apply to like private actors. That was pretty good, and just like slammed the door right in her face. And that Justice Breyer, who was also there at the same time, was like, yeah, also that too. So they like both agreed. It was great because they were talking about, it was it Nancy Pelosi? No, it wasn't Pelosi. It might have been Pelosi. A Boxer? No, because Pelosi's in the House. And I'm pretty sure it was the Senate. Was it Boxer? It was one of the female senators or representatives from California, and he just like basically schooled them. Let me see if I can find the quote or find it if real fast, because it was like, it was a great little moment. It's just like, you know. Feinstein. That's who it was. Dianne Feinstein. Yeah. All right. There we go. All right. Explain the basics, Scalia. Explain it in small, easy to understand words.
America is represented by the distinction of this great court. And now I want to ask you something about the 14th Amendment, and if both of you could respond to it. It's simple. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. Is a woman included within that definition?
Yeah. A woman's a person. I think that's well established.
Yeah, the issue is not whether a woman's a person. The issue is what the issue is what constitutes equal protection.
Yes, all right. Are women included?
Yeah.
Of course they're included.
Yeah.
Well, let me ask you.
But does equal protection mean that you have to have unisex toilets? I mean, that's the kind of question you have to get into.
This is your quote, Mr. Justice, in California. Certainly, the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. Nobody ever thought that's what it meant. Nobody ever voted for that. If the current society wants to outlaw discrimination by sex, hey, we have things called legislatures, and they enact things called laws. So why doesn't the 14th Amendment then cover women?
The 14th Amendment, Senator, does not apply to private discrimination. I was speaking of Title VII and laws that prohibit private discrimination. The 14th Amendment says nothing about private discrimination, only discrimination by government.
Yes.
So, oh, I see what you meant.
Yeah.
Okay.
Yeah. So Scalia gives this statement at this school.
It was a story that touched hearts across the nation.
Shut up, YouTube. Scalia gives this statement at this school, and he's like, okay, yeah, the Constitution doesn't forbid discrimination. He's like, well, I was talking about private discrimination because the Constitution only prohibits discrimination by the government. Oh, and I was talking about Title VII. And I was talking about, yeah, so no. And Breyer's like, yep, that's right. It's like, yep, correct. So yeah, that's a great moment there. That's a great Scalia moment. I wonder if Justice Scalia had thought to ask, do you know what a woman is? I'm sure she would have answered because back then people knew what the answer was. But yeah. You take issue with Citizens United? I think it was correctly decided. I've discussed it many times. I think Citizens United was correctly decided. Citizens United is all about the facilitation of speech. It's like using money to facilitate speech, which has to be protected. So I continue to think Citizens United was correctly decided. So, but that's me. All right, I guess I'm going to go sign off for now. We might be on later today. Apparently there's a school shooting that happened today at Appalachia High School. They're saying 4 are dead. Suspect apparently is in custody. The suspect might himself be 14, which would presumably make him a freshman in high school. And 9 people are apparently injured. So that is happening. And also, Hannah Gutierrez Reed took a plea deal, apparently, today in her other gun case. So let me read that real fast and see, because we might want to do a live on that later. Pleads guilty to the unlawful carrying of a firearm in a liquor establishment. Sentence of 18 months supervised. She was facing some pretty serious time. And so it looks like basically, is that on top of what she was already doing? Or is that running alongside? It's all deferred. It's all deferred. So she doesn't have to go to prison at all if she satisfies her parole. Oh, that's a good deal for her. And so it looks fine. Good for her. So looks like she only has to serve the time on the Baldwin conviction, and the other conviction is deferred, favoring probation. So nice. Did I see Elon Musk telling Newsom the parody is legal in America over a fake Harris ad? I did not. Yeah. Well, I'll explain Citizens United. I'll explain my feelings on Citizens United, okay? In Citizens United, the United States Congress passed a law that very strictly regulated speech, particularly as it was getting close to an election. So it was like the 90 days prior to an election or 180 days prior to election or whatever it was. And there were some very tight limits on what could be done. And the titular Citizens United was a group of people who wanted to produce a movie about Hillary Clinton and why she sucked. And they wanted to promote the movie. And of course, they wanted to show the movie in the run up to the election, because obviously that's when it would do the most good. So they wanted to produce and air this movie in the run up to the election. And they were going to pay for this movie to be promoted. They were going to pay for it to be aired on various streaming platforms or in movies, theaters, or I forget exactly what, but they were going to pay for this movie to be shown themselves. And so it would be seen by people. So it was a expenditure for them, and they could not spend the money. They couldn't spend the money because they were capped. So this independent group who wanted to run a movie saying Hillary Clinton sucked could not get the contracts that they were willing to pay for because Citizens United restricted the amount of money that they were allowed to spend. And obviously the amount of money they needed was more than that because it's an expensive proposition. And so when it got to the Supreme Court, the people in favor of Citizens United, because one of the questions was, well, what about a book? So it's like, okay, how does this work for a book? It's like, could a publisher publish a book about Hillary Clinton, how she sucks? And the answer was, well, no. If you would exceed the money, if you exceed the monetary limits, you can't publish the book either. You can't publish the book. And it's like, okay, so could the government actually go so far as to like forbid the sale of this book? Could they go so far as to like take it out of libraries? And the answer was like, yes, they could. They absolutely could. Right. And so that was kind of the death nail for the argument, right? Because it's like, well, we're not gonna have a law that says you can't print a book. I mean, that's stupid. It's like you can't print a book that's specifically about politics, which is about as core First Amendment as it gets. It's like, it's not just Harry Potter. It is Hillary Clinton sucks balls. Please don't vote for her. Which is pretty core political speech, right? It's core political speech. And you can't print this book or distribute this book or sell this book specifically in the 90 days or 180 days or whatever it was in the run up to the election. Like any other time is fine, But not in that period. You can't sell your book or promote your book or sell your book that time, or your movie, as the case happened to be. And the Supreme Court said that was really, really dumb. And I agree. It is really, really dumb. Because you obviously have the right to say it, right? You obviously have the right to say Hillary Clinton sucks or Hillary Clinton is great. I mean, that's core political speech, obviously, right? That's core political speech. So you obviously have the right to say it. But if you can't pay for it, that restricts your distribution significantly. It's like, why shouldn't I be able to pay for it? I mean, I can stand on the street corner on my soapbox and say whatever I want to say for free. I can do that for free and talk to whoever wants to walk by. But both today and in 1790, if I wanted to I could do that free. I could do that free today, and I could do that for free in 1790. But both today and in 1790, if I want to do anything more than that, I'm gonna have to pay. Paper has to be paid for. Printing presses have to be paid for. Distribution has to be paid for. It has to be paid for. So if you restrict money, you restrict distribution. And so it's like, well, that doesn't make any sense. If I really want to, if I really think my message is important enough, why shouldn't I be allowed to write a book saying Hillary Clinton is a buffoon? And why shouldn't I be allowed to send a copy of that book to every single American in the United States? Why shouldn't I be allowed to go down to my post office and put a stamp on it to 300 million people and be like, here is a book, please read it? Why shouldn't I be allowed to do that? Right? And so, but if I can't spend the money, I can't do it. So restricting money restricts distribution of speech. So that's the core of Citizens United. So that's it. If people genuinely believe their political beliefs, they go out on campaign for free. First of all, no. Some people would go out and campaign, but every political operation costs money. You don't think the Joe Biden campaign, it costs money to even make phone calls. It costs money to knock on doors. You usually have to pay people for that. I mean, some people will do it for free, but usually you're paying them something, even if it's like $50 or something for their time, or, they're buying them food or something. It's like, there's very little free lunches. And it's like, so yeah. And so that's it. So, it costs money to staff those phone lines. It costs money to run political ads. It costs the Hillary Clinton campaign, or the Biden campaign, or the Harris campaign, or the Trump campaign spend oodles and oodles of money on all kinds of speech. It costs lots of money to run a campaign. Lots of other people want to spend money to run their campaign and spread their ideas. It's like, you shouldn't necessarily be limited to word of mouth. You shouldn't be limited to grassroots. I mean, that's a valid way to do it, but it shouldn't necessarily be the only way to do it. You shouldn't be limited only to things that don't cost money. So that's like, the thing. Yeah, it wasn't that the money couldn't be made. It was just the PAC couldn't spend the money to do it. Yeah, or distribute the movie. They couldn't make the agreements to distribute the movie, was, I think, the principal problem. They couldn't pay for the slots in the movie theater. They couldn't pay for the slots on the streaming services. They couldn't pay for those things. So, yeah. Yeah, stuff costs money. Stuff costs money. Yeah. The paper costs money. The ink costs money. Phone lines cost money. Getting out the word to your donors costs money. Getting them together to go to the polls everything costs money. So, and that is not a new problem. That is not a new problem. That is as much a problem now as it was in 1790. The problem is not new. So money has always been a factor in this equation. So you're limiting freedom of press, because you're limiting the amount of press you can do. You're limiting people's access to the printing press in a very literal sense. you're limiting how much printing press they're allowed to have. That's the limitation on the printing press. That's the limitation on press. So limitation, the right that's at issue is probably more freedom of press than freedom of speech. But either way, no matter how you frame it, it's like still a fundamental problem. It really is a First Amendment issue. I just think it's a freedom of press issue rather than a freedom of speech issue, in my characterization. So I think it's a First Amendment problem. It's also a right to petition problem. There's many different First Amendment rights, but I think the primary right that's at issue is freedom of press, because you're literally restricting people's access to the printing press, because the printing press costs money, and that's a freedom of press problem. So for me, the freedom of press is the primary problem, not freedom of speech. But that's my framing of the problem, but still a problem. Are chat rules restrictions on freedom of speech? But I'm not the government. So I can restrict your speech all I want, because I'm not the government. All right, I'm going to go ahead and sign off for now. I will talk to you later. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.